No relation to Molly. I'm a journalist with the Appeal. Recently, I reported on Mississippi's habitual offender laws. And in the course of that reporting, I learned that they, along with other laws in the state, are really important to understanding the over-incarceration that plays a large role in the prison crisis that's going on down there. So we're lucky to have Molly and Andre join us today. So before I kick it over to them, I just wanted to go over a few statistics regarding habitual laws in Mississippi. So approximately 2,600 people are incarcerated in Mississippi as a result of habitual laws. Of those, 1/3 have received sentences of 20 years or more, and half of that group, which is 439 people, have been sentenced to die in prison through sentences of either life without the possibility of parole or of more than 50 years. And this is all from a recent report from an advocacy group called Forward.us. And that report came out last year and was very enlightening about the laws down in Mississippi. And that report also found that 77 people are sentenced as habitual offenders to 50 years or more for just drug crimes alone. And in Mississippi, where the population is 38% Black, 75% of the people sentenced to 20 years or more under habitual laws are Black men. So obviously there's a lot of racial disparity going on. So I know that's a lot of numbers that I just threw at you. And we're going to unpack these laws with Molly and Andre today. And of course, I also wanted to point out that habitual laws are just like not unique to Mississippi. You probably were aware of a case out of Alabama, Willie Simmons, which grabbed national attention recently, and he was sentenced to 38 years for stealing $9 under Alabama's habitual laws. So these laws are extremely problematic, obviously. So to begin, I think it's probably best if you can just go ahead and introduce yourselves, Molly and Andre, and just tell us the work that you've done with these laws.
Sure, I'll go ahead and start. My name is Molly Gill. I'm the Vice President of Policy for FAM. FAM is a nonpartisan nonprofit organization headquartered in Washington, D.C., and we work in various states around the country on sentencing reform, prison oversight, compassionate release for sick and elderly prisoners, and second look laws so that we can come back and reevaluate some of these longer sentences. And FAM stands for Families Against Mandatory Minimums. That's what the acronym means. And so we have always been against mandatory sentences that take sentencing discretion away from judges and essentially force judges to put people in prison for long sentences, whether the sentence is appropriate or not, regardless of the person's background and criminal history and needs. And we see this as a waste of taxpayer money. We see it as bad for public safety because we're spending public safety and prison resources on people who may not need them. And I think habitual offender laws are sort of the perfect example of how mandatory sentences can go awry. You have people who may have a minor prior record that happened a long time ago, and they commit a minor current offense for some kind of legitimate reason, like perhaps they're selling drugs to fund their own addiction, and that's what's driving their criminal conduct. And the judge can't really consider all of that. You know, this in Mississippi, the habitual offender law says that if you have 2 prior felonies, the judge has to give you the maximum sentence for whatever your 3rd felony is. So, for example, there's the story of Paul Hauser, who had 2 prior drug possession felony charges that he was convicted of, and had struggled with addiction for many years. Started selling drugs to fund his own addiction, got convicted for that 3rd felony, and is now doing a 60-year sentence in Mississippi prisons. He served 13 years. He's 57 years old, and he's going to die in there unless we make some kind of reform that is retroactive. So I'll let Andre talk more because of his background.
All right, thanks. I'm Andre Gruy. I'm the state public defender for Mississippi. I've been in this position about 3 years. I've been a public defender in Mississippi for about 30 years. And when we started looking at criminal justice reform in 2013, I was at that time still doing death penalty representation, which has been most of my career. I was put on a task force to look into why we were number 2 in the country in incarceration. Made some suggestions to the legislature. They followed most of them, and it got us from number 2 to number 3, and then we didn't do anything really significant since 2014. And I think we're about to move back into number 2. One of the interesting things about Mississippi that I think people who don't know say, well, why is Mississippi number 2 or number 3 in incarceration? They must have a terrible crime problem there, and we really don't. We're about the middle of the pack when you look at crime reporting, and so why are we leading the pack in incarceration? And some of the reasons for that are the use of, in this complete prosecutor discretion on whether or not these habitual sentences are used. But we elect judges, and they are the ones that impose sentences in a lot of cases. But it's really prosecutor discretion. And once you mentioned Paul Hauser, a sentence that should have been, I say should have been, if anything at all, 8 years with 2 years parole eligibility. And he's got 60 years where he is going to serve every day. And so it's not just these habitual sentences. We have a lot of other mandatory sentences that we put in the strictest truth in sentencing law in the country in 95. We applied it to everybody. And while we backed off some of that, we still have almost half of the people in prison not serving 85%, but serving 100% of the sentence imposed. And the things that I hope you're seeing all over the country, the news out of Mississippi, where we've had 10 deaths in 3 weeks. And we're a small state. We number 2 in incarceration, we lock up 19,000 people. And to have 10 deaths, if you had a small town of 19,000 and there were 10 deaths in 3 weeks, people would be, as they are, coming in and really demanding some change. So this is one small part of it, but we talk about over 2,600 people out of 19,000 is a significant number, and they contribute to that 46% that are not eligible for any form of early release.
Sorry, I was on mute. Andre, could you tell us the root of Mississippi's habitual laws? What are they? How do they work? What role do the district attorneys play?
Sure. They were passed in the mid 70s, which is really the beginning of this, what led to this mass incarceration in Mississippi and around the country, where we started passing these 3 strike laws. So in 1976, they passed them. I think probably a lot of reaction to the unrest of the 1960s and Mississippi being a very conservative state and all the change going on. They were ripe for overreacting to situations. And so we have these 2 laws, Section 81 and Section 83. And 83 is the life habitual. If you have 2 prior offenses and you've served a year on each one of them, and one of them is violent, your sentence is life without parole. If under Section 81, you don't have to have served any time at all, just being given a year or more, which means it's a felony. and then the judge has to impose the maximum sentence for the third offense, and it's 100% time. It's day for day. Now, there was a change made in 2018 that gives judges discretion if they make specific findings that it would be inappropriate. So the burden's all on the person going before the judge. The judge can give less time. Still can't give you parole eligibility. Can't give you you're going to still serve 100%, but he can give a reduced sentence. So kind of a few things on that 2,600, about 400 are people serving these life without parole sentences. They're going to die in prison. We're not even talking about the other 100 or so that just have these really long terms. Of those approximately 400 people, a third of them are actually serving life without parole for a nonviolent offense. We represented a client here that was it was possession of marijuana, what we call simple possession. It wasn't selling marijuana. It was just having the felony level marijuana, and she ends up with what would have been a maximum 3-year sentence, life without parole, because she had a manslaughter conviction. She had 2 prior convictions, one of them being a manslaughter conviction, which is a violent crime, but it's not intent to kill. If it's manslaughter, it could be an accident, it could be gross negligence. So they don't look at what happened in the earlier crime. What are the circumstances of the earlier crime? It's just, is there a conviction? Is it a crime of violence under our definition of violence? Which is, we didn't have it at all until 2014, and it's very broad now. It doesn't necessarily mean intentional violence. It's just the result is violence. So, the problems of most of these sentences being applied, it was mentioned earlier, that we have, I don't remember the percentage that are, I think 75% are used against African Americans. And that's not only grossly disproportionate to the general population, but if you look at the prison population, only 62% are African American. That's problem enough in a state that has 37% African American. But why is it being used against African Americans more than others? And there's nobody looking into that. So we really need to, we are now shining some light on this, saying there are so many different problems with it. And ultimately, it is all the decision of the prosecutor. He can decide whether or not to charge as a habitual.
Thank you. So Molly, you mentioned Paul Hauser's case. I know FAM was the first organization to bring his case to a national audience. So I was just hoping that you could maybe get into more detail about his case, and also just tell us, in the course of learning about it, what did you learn about how these laws impact families of people who are sentenced under them?
Yeah, Paul Hauser's story is so tragic in some ways, because I think it's probably so very common. He had an incredibly difficult childhood. His mother left his father, took all of his siblings with him. It was really just him and his dad. In his own words, he says, "I never really had a childhood." He worked, pretty much full time with his father from a young age, and I think he just had a very painful and lonely and traumatic upbringing. And he started, using substances at a young age, became addicted at a young age. Nonetheless, was, sort of able to sort of put together a life for himself and have a family. He has a son, and that son has grown up without his dad, because for the last 13 years, his father has been in prison. His father went to prison as a 44-year-old man, and now he's, you know, been in about 13 years. And so he's missing, you know, his son's life, and he's missing all of these family milestones that we always think of. And, you know, there are people who say, well, too bad, do the crime, do the time. The problem, though, is that the time doesn't fit the crime. And I don't think even Paul would say that he shouldn't have been held accountable. I think he would simply say, give me a sentence that is reasonable for what I've done. And I don't think by any estimation 60 years is a reasonable sentence for a man with his record and who committed the kind of offense that he did. And this is what we have to think about when we think about sentencing reform, is that you're not just sentencing one person, you're sentencing an entire family. You're depriving the community of a person who was working, paying taxes. Paul did all those things. And, you know, these things have ripple effects. They have ripple effects in our economy. They have ripple effects in in generations of families. It's not just one generation that's impacted. So these are the kinds of things that we can't necessarily put dollars and figures on, but that are nonetheless incredibly expensive costs to our society when we use one-size-fits-all sentencing and excessive sentencing.
Yeah, Lauren, can I say something about Paul's sentence and how it got to be 60 years day for day? So he's got this situation in 2014, we changed the law to address, you know, the old law was if it's a sale, which may be a hand-to-hand transaction, and I think that's what we were talking about in Paul's case, was just a small level transaction. It used to be 0 to 30, no matter what, no matter how much it was. And we saw a lot of people who were technically doing sales. They were actually like doing a transfer and getting a little bit of drugs in exchange for being that person who did the transfer. And they were facing 0 to 30. And then because he had a prior drug conviction, a possession case, that was doubled. So that's how he got to the 60 years. We did two things in 2014. One, set up a schedule so that if you're trafficking, you're going to face a harsh sentence. If it's a low-level sale, probably to feed an addiction, then the sentence range is shorter. I think they're still too long, but so that law now applies to people other than Paul because of the habitual. But anybody else who had gotten this 60-year sentence, even if he hadn't been a habitual, so somebody with a low-level sale and a prior simple possession, would have gotten that 60 years, and it would have been day for day in 2014. We changed that in 2014, lowered the sentence, and while we still allow them to double, we made them parole eligible. So the reason none of those two advances didn't help Paul, because he'd be almost ready to get out if they applied to him. But it's that the second simple possession that put him into the habitual, that now even the reforms we made, he's not eligible. You know, there was one little safety valve in 2014 that we said, you know, okay, somebody, we didn't know about Paul, but somebody like that, rather than automatically making him parole eligible, we, you know, we didn't go back and resentence people. We should have, but we at least made the parole retroactive. We had this little provision that you could ask the sentencing judge to grant you parole eligibility, not to give you parole, not to let you out, just to give you a chance to go before the parole board. And you know, we had 1,600 people who were qualified for what we call G3. It was added provision to the parole law. So 1,600 people eligible for this G3 relief, and we've had less than a handful that because the judges are just not granting it. I think at one point, and unfortunately, the Department of Corrections doesn't track how many have been granted. We've only been able to account for less than 24. So out of 1,600 people who should have benefited, only 24. And, you know, and just said Paul's, the district he comes out of, they haven't given any. So even as his 2-year came up and he tried to petition, the chances of him getting it are very slim. So I just want to like give some more context to, others have benefited with just this really small habitual. And, anybody who knows anything about drug addiction knows you're going to relapse. It's going to happen. You're very more likely than not, if you've got one, you're going to have two. And for that to be, it's really his addiction being used against him.
Andre, is Paul Hauser's story typical to the types of stories you see down there for habitual offenders? I know you mentioned also the case of Willie Nash, who was recently sentenced to 12 years in prison for having a cell phone in jail. And although he wasn't necessarily a habitual offender, he was affected by these laws. So any other examples, or if you could just expand upon that, that would be great.
That's sort of we know the 1,600 of the 2,600 who are in there for nonviolent crimes, but they're really being treated as the worst of the violent offenders. They're because of this. We know a lot of those are nonviolent. Their third offense is all nonviolent. But the thing that you don't see in the data is the number of people like Mr. Nash who because of old, I think they were 15, the most recent one was 15 years old, something that happened when he was 21 years old. And at 40, it was being used against him. My example of how it's used again, how the habitual laws are used against him, the judge gave him this incredibly long sentence. We don't know of anyone else in the system for possession of a cell phone, even in the penitentiary, even under whatever circumstances, getting 12 years to serve. And what the judge said when he sentenced him was, you have these two priors. You could have been indicted as a habitual. I could have been giving you 15 mandatory years. So 12 years with parole eligibility, I'm really cutting you a deal. And so we see that happen and I'm not a line public defender anymore, but the folks out there doing this every day are confronted with cases where they bring a plea offer to their client and they say, this is the offer. And if you don't take it, he's going to file a motion to enhance you as a habitual. And then you're looking at mandatory time. So the effect of what I consider extorting pleas on sometimes weak cases, sometimes cases that really aren't a crime, that, the situation of our client, Tamika, who had some marijuana and now she's doing life in prison for having that marijuana. Sometimes people just, why they go to trial facing that is incredible. But so that hidden number that we can't put, that we don't know how many are entering pleas to crimes they might not have committed, or maybe there's not really sufficient evidence of a crime, but facing a mandatory sentence, and especially life without parole, as a risk, you're going to take a plea.
So we know right now that Mississippi's prisons are in crisis. They have been for a few years, but now they've drawn national attention, rightly so. Even today, like Jay-Z and Yo Gotti are hosting a rally in Jackson for prison reform. So I just wanted to ask you, Molly, FAM has been out front on asking the DOJ to investigate Mississippi's prisons. How do these habitual laws fit into the current crisis down there?
Sure. I think it's very simple. Bad prisons are just a symptom of bad sentencing. When you have overcrowded, understaffed prisons, you should start looking at, why do we have so many people in here? Why are our prisons so crowded? What is going on? And it's not the DOC who's usually involved in that. It's the legislature. And so you have to go look at the sentencing laws. You have to ask yourself, who are we putting in prison who doesn't need to be there? Who are we putting in prison for far too long? What are all smarter, cheaper alternatives that we can use? And these habitual offender sentencing laws, I think, are just one of the best examples I can think of sentences that make no sense. We've heard several stories in here: a woman doing life without parole for a small amount of marijuana, Paul Hauser doing 60 years for a hand-to-hand sale. These sentences make no sense for public safety. And when you fill your prisons, and even when the habitual offender law isn't being used, getting 12 years for having a cell phone in jail, these are the sentencing decisions that need to be reassessed, and the laws need to be changed so that we can reduce the prison population. You can build the best, nicest prisons you want in the world, but if you are still putting too many people in there, they're still going to be overcrowded and understaffed. They're still going to be dangerous. They're still going to be hellacious places for people to live. And sentencing reform is the solution to all of this. It's step one.
So the problem isn't necessarily cell phones, as Tate Reeves said in a press conference today.
I read that article, and I have to admit, I think the list of items that he listed as reforms are not going to get it done. We need to have serious sentencing reform. I think we need to close Parchman. That's been a campaign that FAM has been running. We just need to shut that prison down. It's got a horrific history. It's a blight on the state of Mississippi. It's unfit for human habitation. It's dangerous for everyone who lives and works there. That prison should just be shuttered and closed. And they need to move people to different facilities. And then, like I said, do the hard work of sitting down and saying, how are we going to reform these laws so that we have a smaller prison population, so that we're preventing this from reoccurring in the future. And I think we're also advocating independent prison oversight. We can avoid prisons turning into places like Parchman, where they're crumbling and infested with rats and roaches, and there's no mattresses or power or running water in so many of the cells. That is all preventable through an independent oversight body who can come in, who can do inspections, who can monitor conditions, who can investigate complaints, who can stop some of these problems before they turn into taxpayer burdens, because these are going to result in lawsuits that drag on for years and cost taxpayers millions of dollars. This is all preventable through better oversight, but more importantly, through sentencing reform.
So these reforms sound like a no-brainer to me, at least. Obviously, people think otherwise. So either of you can take this one. Why haven't reforms been enacted? I guess meaningful reforms, and who's resisting them, and why are they resisting them?
Well, I'll tell you, last Friday, I'm on the Corrections and Criminal Justice Oversight Task Force, and it sounds a lot more important than it is, because we're not providing oversight. We're looking at the reforms that we started in 2014. We really go back to the 2013 task force report and look at how things are going, how it's being implemented. We have made some changes along the way. The legislature has responded. In 2017, I believe, the legislature passed a law that would have made all of the 81 habituals, people like Paul, so nonviolent, never violence in their past, and that's about 15 of the 1,600 people we're talking about, would have made them parole eligible at 25%. So again, Paul, because he had this extreme sentence, would have still had a couple of years to go. The governor vetoed that. I think that a lot of the opposition comes, the prosecutors, they like these tools that they have of hanging these sentences over people's heads. We came back in 2018 and gave judges the authority to go below the maximum. And we just got the data report. It's the average sentence length in 2018, the FY18, the year before it went into effect, was 107 months. In 2019, when they could now exercise this discretion to go below, 111 months. So it's like almost a 4% increase in the average sentence length when they were given this extra tool. So a lot of it, I mean, these are requiring a cultural change. What I was going to say when I presented to this task force this idea of reclassifying, similar to what was done in Oklahoma a couple of years ago, why I think Oklahoma is going to slip past us and drop down to number 3 in incarceration. Reclassifying simple possession, and it doesn't decriminalize it, it just makes it a misdemeanor instead of a felony. And the opposition was, the prosecutor's representative was just opposed to it. He's just opposed. He's opposed to anything that's going to reduce any sentence ranges. I had some quiet support from a couple of the 2 sheriffs that are on there, but leaning over to me at the table and saying I'm with you is not the same as voting to support me. But the judge who has a really good, he uses the intervention courts, drug courts, veterans courts, mental health courts, and goes out and gets grant money. He's doing it the way we wish every one of our judges would do. But he explained to the group that, he really doesn't want to reduce it from a felony to a misdemeanor because, and I think I'm right on this, he said he needs that brick over their head so to make sure they do right in drug court. And we've heard in the past that our reforms were terrible because they lessened the punishment that some of the time that somebody would have to serve. So they opted to go to prison instead of drug court, which might tell you something about your drug court if you'd rather go to prison than go to the drug court. So, they're well-intentioned people. They think that if they provide you with enough oversight, they can make you do right. And, I don't think they're the vast majority of our opposition, which is really, it's coming from prosecutors and some judges, that it's because these are bad people and want to throw people in prison. I think it's that they're afraid and they don't know another way, and they're politicians and they live on power, and you can't just, if you give up some of your power, where's it going? They worry.
Do you think also it has to do with the fact that they don't want to disappoint their constituents and just sort of like the general, I guess, mindset around crime down there? And I don't know, is there any way that
Well,
could be involved?
I think there's definitely, the feeling that they don't want to get out in front of this. They're not sure if the people in their community would even support something like this. But there was some polling done last year that supported this. So I think, and I'll tell you that in some ways we wanted an overhaul of the intervention courts, but mostly drug courts, so that we make sure they're using best practices and really serving the people that are in them and getting them not just a delayed sentencing, but actually getting them treatment so that they can deal with their addiction and get back to work. That it's just kind of, maybe I got to be careful about what I say sometimes. It's the task force is, even because it's these constituent groups like law enforcement and the prosecutors, they're not as tuned into the voters as the actual legislators, because when we couldn't get the intervention court overhaul passed in the task force, and it got presented in the legislature anyway, and the legislature passed it. And so we're hoping with what's going on now, and everybody's got their attention, and there was some criticism of some of the things, and I've heard it earlier today on my way in, that things that the governor said. We have the governor's attention now like we've never had. We have the lieutenant governor's attention and the speaker's attention, and I think it's reflected in some of the committee chairs. And so we're hopeful that we've got people's attention, and they know that this problem. I heard from a legislator the other day, I didn't know it was this bad. And I'm like, where have you been? Why aren't you listening to us? We're not telling you it's this bad. But now, and quite frankly, oversight's great. Whistleblower protection and oversight is what's necessary, because there are people that are working as corrections officers and people who are inmates who face retaliation, and their families face extortion. And if so, when somebody reports something, if the result is their family member gets roughed up by the guards, then they're not going to do that. So there has to be whistleblower protection. Nobody got stabbed with a phone. Nobody got beaten to death with a phone. But people took pictures of what was happening and shared it with the world with those phones. So, I'm not saying we should have phones in there. But the phones didn't cause the problem. There's no evidence the phones caused the problem. There is evidence that the phones contributed to bringing this all to light, like everybody says we want now, transparency. So the folks with the phones that are making change by sharing what's happening need to have some protection when we look at oversight.
Did you want to add anything to that, Molly?
Just that I agree, and we've been working on oversight bills in several states, and are being technical advisors in Mississippi to the extent that we're asked. And definitely one of the protections that we have in there are anti-retaliation measures and whistleblower protections. And I agree, you can't do anything unless people feel like there's a safe place for them to go and complain. And you can't do anything if that body isn't independent, if it's not fully staffed, if it's not fully funded, if it doesn't have a mandate, and if the DOC doesn't have to listen to them. We need to have all of these requirements in these oversight proposals, and certainly FAM would be supportive of that in Mississippi as well as in other states. And I think the fact that every day now I see a terrible story about someone who is being assaulted in a prison or raped in a prison or committing suicide in a prison, or there's a riot in a prison. It's getting worse, not better. And the only way that we're going to stop that is if we have someone with some real power who can go in there and tell us what's happening and why it's happening, and who can demand some change. And I am encouraged to see the governor making this statement today. And like I said, I don't think his proposals are the going to get us to where we need to be, but I'm encouraged that people are paying attention. And I think that media coverage has been a key part of that as well. So I would just encourage you, Lauren, to keep covering this topic, because if lawmakers aren't reading about it in the paper, they don't care about it. And there are just too many people being impacted for lawmakers not to care.
Yeah, I guess now is a good time to plug my piece on the appeal that came out today. It's about a woman who died in August 2018, and it was said to be from natural causes. And then her dad hired a lawyer, and then they go and find out that she was actually beaten and was not provided medical help, and that guards didn't do anything to stop the attack. So you guys can read about that on the appeal, but it's probably, very, I doubt that it's a rarity in terms of the people that have died there, because I know that MDOC has sort of said a lot of them are natural causes, and obviously you come to find out later that that's not exactly true. So I guess for my final question, I just want to ask you both, what needs to be done to ensure that people like Paul Hauser aren't dying in prison, and that, people aren't being sentenced to these extreme sentences down in Mississippi, and how can those be achieved?
Well, I think one of the provisions that FAM's been advocating, and that has been, it's not a new concept, it's actually a really old concept, is the concept of a second look, creating a legislative, passing a bill with a mechanism so that courts can go back and reevaluate these sentences. Paul Hauser's been in there for 13 years. And if he could go back in front of a court, the court could look at, is this person still a public safety threat? Does this punishment still make sense for this person? So I think having a second look mechanism like that can get a lot of people who are in there now, can give them an opportunity to go prove that they are no longer a danger and should rejoin society. I think that's supposed to be the function of parole. I think many parole boards are broken in this country, and they're not releasing people, and that's a problem. So we need to look very seriously at other mechanisms if parole is not functioning the way that it should be. I think medical and geriatric release is the same concept, except for looking at people who are very ill or very elderly, and FAM's written extensively on the use of compassionate release around the country. We have a report at our website, famm.org. Our compassionate release section of our website talks about how states all over the country have these release mechanisms, but again, they don't work very well. And so we need to reevaluate those and really ask ourselves, what can we do to make sure that our prisons don't look like nursing homes, because that doesn't make us safer. And I think clemency is another thing that I would hope very much that governors would use more of. And I mean, of course, all of this could be avoided if we simply made sentencing reforms and made them retroactive. If a law is unfair today and I change it tomorrow, then the person who was sentenced yesterday should be able to go back to court and have the new fair law applied to them. And I think this is a really basic concept of justice. I think, lay people get this all the time. Lawmakers are reluctant to do it because they don't want to be seen as letting people out of jail early. But it is a matter of fundamental fairness, and it is absolutely essential to clearing out, frankly, some of these folks who just don't need to be there anymore.
Yeah, geriatric parole is something we tried to look at it a couple of years ago in the corrections task force, and everybody fussed at the parole board chairman so much he threw up his hands and walked away. We passed geriatric parole in HB 585, but by the time it got through the committee process and they put all of the exceptions on it, I was convinced that there wasn't anybody that was going to qualify. They've just done the data on it, on people, and they're looking at people 60 and older. I was wrong. There is, I think, 3 people who qualify out of 1,061. And so there is going to be a proposal. It's been introduced by the Senate Corrections Chairman, and I think hopefully he has some others join him that would, and hopefully the Corrections Task Force report will come out later today, and we'll have enough votes to include geriatric parole. It's got, these are older people, their healthcare costs. Even our chairman talks about his visit to Parchman, where you're watching people in wheelchairs. I really don't think you're going to break into a house just because you did it 25 years ago if you're in a wheelchair. So at a minimum, I hope we look seriously at geriatric parole, but we have to overhaul our entire parole law. We've got so many exclusions. 30% of the people in prison are eligible for parole. And it's just we've got all forms of earned release need to be looked at, because just a little over half earn anything. But when only a third of the people, it's not the parole board's fault when only a third of the people can even be considered. So we've got a lot of work to do. There's so many. If you've got an idea from anywhere in the country on prison reform, it would apply in Mississippi. It would benefit in Mississippi, because there's very little that we've done so far.
All right, well, I think those are all my questions for today. Is there anything else that you guys wanted to add? No.
Hey, thanks for having us. And
Yeah, thanks.
Yeah, no worries. Thanks for joining us. This was very enlightening.
Thank you. Take care.
You too. Bye.